Gotta love this process. It's sometimes it works, and sometimes it's not so easy. But I guess before we begin the live, why don't you just take a minute to introduce yourself to the Yesh Tikva community?
My name is Rebecca Mendel. I'm with the law firm Rosenstein Higgin Mendel, based in New York City. I am licensed to practice law in New York and New Jersey. I have been practicing since 1998, and I have primarily, my firm does obviously surrogacy and assisted reproduction, as well as adoption and foster care litigation. We do a lot of family law. I'm also a member of Quad A and a member of the New York Attorneys for Adoption and Family Formation.
Amazing. Thank you so much for being here today with us to answer some legal-ended questions around the surrogacy process. Last week, we spoke a little bit about an overview of what to expect somewhat from start to finish from the intended parent experience of having a child through using a gestational carrier, as well as what it would look like a little bit from the end of a surrogate who would like to be part of that process. But today we want to delve into the legal aspects of that. And I guess to start off, could one go through the process of surrogacy without a lawyer?
Most likely not. It would be extremely complicated for multiple reasons. One, most importantly, is that entering into an agreement such as this, everybody has to make a knowing and voluntary decision. And that's hard to do when you are not advised by counsel. New York, for example, has a requirement that each party has independent counsel licensed by the state of New York. And I'm sure many states are exactly the same way.
Amazing. And that makes a lot of sense. That way each party is protected and their lawyer has their best interest at heart. Amazing. We got some great questions from the community, so I'm just going to take a look and ask you some of these. What are, I guess, in an overview type of way, what are some of the legal issues that may arise throughout the process that a lawyer would help guide you through, in addition to creating this agreement that needs to be signed by both parties? Are there other aspects?
Well, an attorney is a really good place to start, so that everybody is aware of the laws of the state that the intended parent or the surrogate is in, so that they understand what the current state of affairs is, so to speak, in their home state. Of course, surrogacy, there will be a choice of law, and it could be decided later what law is going to be there. But at the very beginning, you want to make sure that you understand at the very least the laws of your state. There are surrogacy and this type of assisted reproduction is a creature of state law. So every state is incredibly different. So I tell people, don't just talk to your friend in California or Illinois or wherever about what they went through, and talk to their attorney, because your process may be very different. So it's good to understand legalities, and it's also good to understand what you can and can't do in terms of promises that you make or things like that. And it's really good also, of course, for an educational purpose to understand what surrogacy is and how much it is collaborative, right? So we want to make sure that everybody really has a good understanding of that. That's the pre-stuff. And that, during the contract negotiations, do you want me to talk about that, or do you want me to wait on it?
That would be amazing. But before we get into that, one follow-up question, what you just said, you mentioned that different states have different laws.
Yes.
What state determines the law that you are following? Is it the state of the surrogate, or is it the state of the intended parent, or is it the state in which the child is born?
So that's a great question, and spoken like every good attorney, I'm going to say it depends. And so it's going to be a decision that's going to be made while we are, making determinations. Some agencies say this is what you're going to do, but honestly, the attorneys will get together and talk about it. The rule of thumb is generally it will be in the state where the surrogate is, just because that vital record, the state vital records will be used to the process in that state. But, there may be restrictions whether intended parents can do surrogacy in that state if they're not residents. So there's lots of, intricacies, and the attorneys come together and, try to figure out which is the best state to do things in and to talk about that, because there are some states that, maybe you can't meet the requirements of eligibility under that state law. So the attorneys are going to get together and figure out where the most appropriate venue is. It is usually in the state where the surrogate is, but it is often in the state maybe where the intended parent is. It won't usually be in the state where the child is born, because that can be so variable, and personally that's a big risk that I wouldn't want to undertake, to try to get venue in the hopes that the child is born there. What if the child is born somewhere else and then all of a sudden you have no venue there?
And so, meaning, if I'm understanding correctly, once the state is chosen, those laws are binding for this agreement, regardless of where the surrogate is living, where the child is born, and where the parents are living.
Correct.
That becomes the binding agreement across all states.
Yeah. So we have in every contract, you're going to have a governing law and choice of jurisdiction paragraph that explains very clearly which state this is doing. So we also will have part of that, what the parentage process is going to look like in that state. We'll go through whether that state, the process for vital records in that state, it will all be talked about during the contract, in the contract itself, and certainly during the contract review with either the surrogate or the intended parents, whoever the attorney is representing.
And it must be honored in all other states once these documents are.
So the agreement. So what happens is you do this agreement that's fully negotiated, and I know we're going to get into some details of that. You ultimately, the attorneys will go into court and get a judgment of parentage, an order of parentage, a pre-birth order. People call it all different things. Yeah. That is the vehicle that has to be given full faith and credit by every state in the country. So it's really important, and by policy, most attorneys are going to file these pre-birth orders in the second trimester, unless you're in a state that doesn't allow pre-birth orders, and then that's something that will be discussed.
Okay, this is so interesting. Thank you for explaining all of this.
I hope I'm making sense. It's all very
Yes, and it's a lot goes into this process. It's not it's so simple as call your friend who did it, and now all of a sudden you know what to go through.
I tell people all the time, right? Like, this is the most important thing in your life is your child and your family. So this is not a time to just go with, what your best friend says to do. This is a time that you want to, I think of it as every single insurance policy out there, to make sure that every I is dotted, T is crossed. You don't want to live in a gray area. This is not something you want to take a risk about, right? You want this to be conservative, and you want this to be, as ironclad as possible.
Definitely, and that makes a lot of sense, and that's wonderful advice. And I know that before we got into this part of the question, you were about to answer the other aspect. So do you want to jump back to what is included in the document?
So, every attorney is going to be a little different, but some general rule of thumb is, obviously you're going to want to put everything in the contract so that there is meeting of the minds about every single aspect of the surrogacy journey. So you're going to want to address how you're eligible under that state law. You're going to, like we talk about which governing law. You're going to want to identify if donor gametes were used, because as part of the parentage process, you're going to want to terminate the rights of any embryo donors, ovum donors, or sperm donors, right? Like all of that gets done as part of the parentage. You're going to talk about the surrogate's obligations, any lifestyle changes she has to make. For example, no tattoos, no piercing, no exposure to kitty litter, things like that. All of that comes up. You want to talk about like what type of communication you're going to have during the pregnancy, whether the intended parents will be invited to all of the doctor's appointments. All of that goes into the agreements. You're going to talk about vaccinations. You're going to talk about intended parents' obligations. For example, in New York, it's a requirement that intended parents have a will in place prior to taking any medication to further an embryo transfer. So that has to be detailed in there. A surrogate will be addressed what happens if she has to go on life support. My policy is to also have her doing a living will for that purpose, because I want that extra step of not just having somebody interpret the agreement. I want a freestanding document to that extent. You're going to address that the intended parents will take custody of birth regardless of, the condition and health of the baby, and that the surrogate will not. You want to, of course, talk about termination and selective reduction and what that looks like, whether you can put things in your contract to that extent. You're going to want to talk about offering this surrogate counseling. And then, of course, you're going to talk about compensation or whatever the state calls it. Some states call it living expenses, some call it compensation, and how the surrogate is going to be compensated, her base compensation, what reimbursement she'll be permitted to have. And, I want to make it always clear if the reimbursement is a reimbursement or if it's coming out of base compensation. All of it will be paid out ultimately through escrow, and that will be also documented, of course, but we want to make our contracts crystal clear for escrow so they don't have any questions about anything. We want to make sure that the surrogate has life insurance in place and address her health insurance issues and see if any additional insurance policies are being taken out, such as a loss of reproductive organs policy or a bed rest policy. There will be an insurance review that is done. You'll address lost wages should things be. This is just rattling off why these contracts are 50 pages long, but there's a lot that goes into it. And of course you have to address childcare if she needs assistance because she's on bed rest. I also put in when it's appropriate, pet boarding, things like that. You have to take into consideration childcare, pet care when she's actually in the hospital. And talk about breast milk and if she's going to pump and whether she'll be compensated for that and what that looks like. Any additional compensation she may get for invasive procedures. And of course, there will be a whole section about what happens if somebody is in breach of the agreement and what that looks like. And all of this should be really, firmly discussed with your clients. And then, what happens if there's death or separation or divorce of any of the parties? What happens in those instances? How long the agreement is? How many embryos are going to be transferred? And, is it 3 attempts within an 18-month period, 1 embryo transfer only? There'll be things about confidentiality, to keep everything confidential. And of course that it's binding on everybody's heirs, in the future. So those are, and of course, how you would amend an agreement if it needs to be amended. So all of those things are just some general topics, of course, that come up in every agreement. And you can see why it's, fully negotiated and why, given all of this information, going back to your first question, why you need an attorney throughout the process.
Yes. Just hearing you rattle off all these different areas felt very overwhelming. So I can only imagine how overwhelming this process must be for both intended parents and a surrogate to go through, which, as you're saying, is so important to have legal counsel representing you who is advocating for you throughout this process to make sure that your needs are being met on both ends of this agreement.
Definitely.
Yeah. I don't even know where to begin. So many questions. Okay.
Well, I do want to just say one thing that I also want to say is that to what you just said, it's really important that intended parents and the surrogate feel supported by his or their attorney, because this is someone who you want to make sure is talking to you, answering your questions, explaining things. So I think it's important for people to talk to a few different people and figure out who they're comfortable with. And this is someone who you want to trust throughout the process. So I do always encourage that. And I'm happy when people choose me, but I understand if they choose someone else. It's a very personal decision that people should be supported. I always say you have a team, you have the agency, you have your attorney, you have your insurance reviewer, you have everyone. You want to be supported by the team that you put in place.
For sure. And that makes a lot of sense. A question, I guess, relating to that is, in this process, what does one seek first? Does one first seek out an agency through which to begin the process of finding a surrogate, or does one first hire an attorney to get the ball rolling?
Well, I think, some people do an independent journey, and that's where they're looking for a surrogate directly and not using an agency. So, it really depends on the person's personal, and whether that's permitted in the state that the intended parent lives in, of course. But I think that, people, a lot of clinics will give, referrals to agencies and attorneys, and I really think it's a personal decision. Obviously, they might want to do a consult with an attorney first, just to talk and get some ideas of these are the agencies that I'm looking at, things like that, or vice versa. But when sometimes people just say, this was the agency that I was told to go with, and then all of a sudden they're like, wait, there were other choices out there, or this is the attorney I was told to go with. So I think it's a personal decision and a comfort level for people. But as an attorney, I'm sort of tied until I can, until there's a match. I'm not really doing as much. I mean, maybe I'm giving some guidance to people, and I do that, or reviewing service agreements for an agency that they're signing up with. But they're really looking for a match. So, I mean, if they don't have embryos yet, it's premature to do anything, right? So they might decide that they want to start off with an agency where they that maybe has an egg donor program attached to it. They might want to do an all-in program or something like that. It's a very hard question to answer, because it is also a very personalized journey question.
And I guess to add on to that question is, you said that if someone were to seek legal counsel at the beginning, most of the work happens only once the match is made. Is one paying a retainer to hold on to legal counsel in between, or not?
I mean,
and would that
I would say I can't say what all attorneys do, right? I mean, for better or worse, I don't know, I guess it's who you're talking to. I don't really want to just hold clients' money up. I mean, people have gone through a lot to get to where they are, and they might not have a match for 8 months, and it may not be even me. They might be matched with a surrogate in another state and decide to retain counsel in, that other state. So I don't.
So you're not retaining counsel in the meantime. It's usually once the process happens that you begin.
Yeah, and that being said, I have certainly been retained by people who say, no, I want to just be able to call you and ask you any questions along the way. Sure, feel free, but if they're really looking for an attorney just to draft their surrogacy agreement, period, and a discussion, that usually happens once all the medical clearances are given and the match is really official. But, people also retain attorneys, like I said, to review a service agreement with an agency, to, discuss things with and all that. So there's different aspects that attorney might get involved.
But the predominant one really is writing that agreement at the
end. Yes.
That makes a lot of sense. Thank you for clarifying.
Yeah.
Okay. We have a question here about what are some of the ethical issues that one should consider when pursuing surrogacy. Is this within the scope of your legal guidance to them, or beyond the scope?
I think it's a little... I think that the ethical considerations, there's legal ethical considerations, that, compliance with the law and things like that. But I do think that there is an ethical and moral obligation to have a respect for the surrogacy process in general. Like it is a time to, surrogates are doing this. Certainly, they need, they deserve to be compensated, but they also want to help a family who wants a baby. Intended parents want their child so badly, and this is the person who's willing to help them. So sometimes, it's about taking a big step back and having a respect for one another and a respect for the process, and then coming together to make sure that when you're negotiating the agreement, you're doing it with love and respect for one another and hearing each other and really wanting to be amenable to each other's needs. So I see it more as a moral thing. The ethical positions are really, the legal stuff. In New York, for example, it is it's in our statute that you cannot force a woman to have a abortion or selective reduction, and anything in the contract to the contrary is void and unenforceable. Mm-hmm. It would be unethical for me to put that in the agreement. It just would. So I will spend time with my clients talking to them about how you went through your joint counseling together, you're philosophically aligned, there is a trust factor here that you just have to do. And if you need another counseling session to, solidify that a little more, then take it, because I'm not going to be able to do something that is not compliant with the statute.
Right. And that makes a lot of sense.
Yeah.
And then we also had a question about what happens if you are living in a state that does not that is not surrogacy friendly. What legal implications does that have for you if you're working with a surrogate in a state that is?
So, that used to be the case in New York, for example. Surrogacy just became legal in New York in February of 2021. But prior to that, everybody knows that people were doing surrogacy from New York all over the place. I mean, forget about people, that everyday people. We all know celebrities that live in New York that, went someplace else. So what couldn't happen, unfortunately, what it was, is that the surrogates who wanted to be surrogates in New York were the ones that were penalized because they couldn't do that for somebody else. Intended parents can go someplace else and submit to the laws of another state, and that's what they tend to do. So that is a piece of why it's important to talk to an attorney, just to figure out where you should go. And as you're deciding about surrogacy-friendly states, which states am I going to look at? But take into account the geography of it. Like New York families who are going to California are having to hop on a flight 6 hours to hopefully, be there for the birth of their child, or every doctor's appointment they want to go. That's another plane ride, another hotel stay. So it's a lot to consider as you decide which state to go with.
For sure. Thank you so much for taking the time to really answer all these questions and to give us a better understanding of the legal implications of this process. Before we end, do you have any last thought or piece of advice that you would want to leave those considering this process?
I would say that it's a very exciting process for everybody. It's exciting for intended parents. It's exciting for surrogates. And it's really a process that does, like I've talked about, require respect for the process. People have been through a lot to get to this place, whether it was ovarian cancer, whether it was, unexplained infertility, whether it was so many different things, that it really is, I think, taking a step back and just remembering that everyone's human is an important piece of the puzzle, and just taking a deep breath and knowing that many people have been through this, and it will, you'll go through it, it's a process that has been well oiled and well defined, and to ask questions. Don't be scared of asking questions. Don't be scared of asking your attorney to ask for something on your behalf, but also, when you are matched through an agency, you have really discussed a lot of things. So if you are on the same page and then all of a sudden do a total 180 and you're asking for something that was never really even discussed and so different from what you had talked about, that's not really fair either. So, really try to stay true to your joint counseling sessions.
Amazing. Thank you so much. This has been so helpful, and I really appreciate you making the time to speak with us today.
Absolutely. Thank you for having me. And, let me know if you have any questions or you receive any questions. I'm happy to answer anything.
Amazing. And we'll definitely tag you in this so that people could reach out in comments and share questions.
All right. Thank you so much.
Thank you.
Okay.